3-4, State of Kansas v. Lindsey Blanchette.
Good morning. Lindsey Blanchette appears through counsel Michelle Davis. May I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. So this is an appeal from a jury trial conviction for first-degree premeditated murder in the death of Ms. Blanchette's young son. The district court also instructed the jury with intentional second-degree murder, and both at the time of the event, Ms. Blanchette suffered from mental illness. Both sides had experts testify. Her expert said that she was in a manic psychotic state characterized by panic, terror, that evil forces were coming to kill her and her son. And the motive for the killing was to save him from the torture and suffering that he was about to endure. We're back before this court on supplemental briefing in light of another case from this court, a recent case that interpreted a statute that applies to a mental illness situation. In 1995-1996, Kansas abolished an affirmative insanity defense by adopting an approach called a mens rea approach that says that this evidence of mental disease or defect, basically, it doesn't say this, but it's interpreted to mean mental disease or defect is only to be considered for the mental state that's required for the crime. And then in 2011, the Recodification Commission, instead of the term criminal intent, or for the term criminal intent, they started using culpability in the culpable mental state. And so that was adopted by the legislature as part of the recodification. And so instead of the statute saying mental state, the statute now says culpable mental state. So our supplemental briefing addressed the applicability of this court's finding that premeditation is not a statutory culpable mental state. And basically, we present two arguments in our supplemental briefing for why there was still error in this case, and it's reversible error. And basically, it's that you cannot interpret this statute to say that a defendant cannot defend against an element of the crime. To do so would go against your previous case law, which is Bethel in Yorick, that this statute, the mental disease or defect statute, is acceptable in abolishing insanity because it doesn't prevent a defendant from doing that. And also that there are situations where a defendant's mental state is relevant or state of mind is relevant. And so outside of the limits of this statute, while this statute provides this defense in regard to the culpable mental state, outside of this statute, there are situations where a defendant can present evidence relevant to their state of mind, and the statute just doesn't govern those situations. And in order for this statute to be constitutional, this court has to interpret it in that manner. So, to give you an example of a situation like that, for example, a soldier who comes home from war, or someone who has been a victim of violent crime, perhaps they're suffering from post-stress PTSD, which basically means that they have a heightened sense of danger. And so they're in a situation where they think somebody's reaching for a gun, and so they use deadly force against that person. A lot of people would consider PTSD to be a mental abnormality or a mental disease or defect. And yet, it can be used in situations where it doesn't negate an element of crime. For example, self-defense. Part of self-defense is a defendant's subjective state of mind. Or imperfect self-defense, where I had this heightened sense of awareness and I believed subjectively that I needed to use force to defend myself. So in that situation, if you applied this statute, this mental disease or defect statute, literally the way the state's arguing to interpret it, where it says mental state defense or defect is not otherwise a defense, then that person couldn't introduce evidence that they suffer from PTSD to show that their claim of
I understand
self-defense is
that
valid.
in terms of self-defense or belief in self-defense, but what about if self-defense isn't involved? If you've thought the matter over beforehand but it wasn't logical thought, if it was delusional thought, is that still premeditation? In other words, you have watched the movie Men in Black and you believe there's all these aliens and that you have to get rid of them, and so you make a plan and prepare to kill people at the post office because you believe they're aliens. And it's delusional thought, but you thought it over beforehand. You did it intentionally. We already know that if you do it intentionally, it doesn't matter if it's delusional thought. So does it matter if your premeditation thought is delusional?
Well, yes, it does, but I don't think that's necessarily the key to this case. Her expert said that because of her mental illness, she didn't lack the ability to reason and control her impulses in a rational manner. Her thoughts were all about this focus on that they were about to be, it was all about defense, and that they were the terror of her situation. So I agree with you that what you're saying, but even without what you're saying, when the jury's instructed, the defense of premeditation is thought the matter over beforehand. Her mental illness evidence was relevant as to whether she thought the matter over beforehand. I mean, the state said that the parties argued here about, the jury was instructed that premeditation is formed the design or intent to kill before they act. The parties argued over that. And the defense here was, no, she didn't. Her plan here had been to give the kids to dad and go commit herself. The state said that the evidence of design or intent to kill before the act was her actions. So if you take away this evidence of mental illness, then that's all that you're left with. Whether she thought the matter over beforehand and all of her evidence of mental illness was relevant to that. I'm trying to give you an example here. For example, the knife and the rock. She said that she took the knife and the rock into the room because that's where she heard the gun drop, and that's where she thought, that's what scared her, the noise that scared her. The state said that that was evidence of this plan because she took two weapons into the room. If you take away the evidence of her mental illness that explains all of her thinking, then all you're left with is her conduct, which is what the state's using to convict her of premeditation. It's evidence, when the jury asked when did she think this over, and the state's trying to say she thought this over beforehand because she took the weapons into the room. But if you need her evidence of mental illness to understand, she said no, it was instantaneous. She said, I formed the intent instantly because it was like a lion in a jungle gaining on me. And it was, I had the knife and the rock there, and I was walking around the house and I'm looking to see, and it was when she's in her son's room, and it's when the evil forces are coming through the door, and this is it. It was in that moment, instantly, she decided she needed to act, that she formed the intent to kill. So if you take away her own reports, that's her mental illness. Her talking about her mental state, and her mental illness is relevant to that question of when she thought the matter over, when she decided to kill. And so if you take all that evidence out in her favor, that explains, even though she had brought these weapons into the room beforehand, that evidence explains her thought process and why it was that she didn't form the intent to kill until right before she acted or right when she acted. And that's the prejudice to her in this case. I mean, that's what this case was all about. And if you tell a jury not to consider that evidence, all you're left with is the state's argument that she formed premeditation because she stabbed him several times, and she formed premeditation because she had previously bought those items into the room. And that evidence, you don't have any explanation for why she did what she did.
I'm having, I guess, a conceptual difficulty tracking your argument that the evidence of mental disease or defect is relevant to this question of timing. Because as at least a simplified version of our McLinn holding is that premeditation is really just a question of timing. It's a question of when. When did the culpable mental state come into existence? Did it happen before, or did it happen coterminous with the crime itself? Would you agree with at least my summary of McLean?
It could be read for that in that manner.
And so if it's just a question of timing, how does the mental disease or defect rebut the state's evidence that the culpable mental state was formed before the actual crime?
Because her mental state, her thought process, her state of mind goes to her motive, which goes to when she formed the intent to kill.
You're saying that,
You're saying it has a timing element, her motive has a timing element inherent in it,
Yes,
and the motive arises out of her mental illness.
right.
And why is the jury precluded from considering that based just on looking at her intent? When you combine the instructions that she must have premeditated and that she must have informed the intent, the premeditation of the criminal act. In other words, before she committed the crime, she had thought of committing the crime, considered it beforehand. Isn't that intent? Aren't you saying the same thing, that the jury would look at whether she could form the intent beforehand?
What the jury was told is that she thought the matter over beforehand, formed the design or intent to kill before the act. So forming the design or the intent to kill, that's the part that I'm focusing on.
Well, but the jury was permitted to consider her mental disease or defect evidence in defense to decide whether or not she formed the intent. I mean, that was permitted.
But not when.
But not when,
But not
right?
when.
That's what we're here arguing about,
Right,
is
because-
whether
right.
cutting that fine line between.
Right, and you needed that evidence to explain.
and when is that line?
I'm sorry?
When is the line between the premeditation and intent?
Well, I would submit to you, as I did in my supplemental brief, that in that case, I cited in my brief, there has to be thought over beforehand, means there's some quantum of reflection.
But we've said that could happen during the murderous act.
That it's evidence, that your actions during the conduct are evidence of premeditation. Because if you're saying that, then you're directly
No,
contradicting your jury
we've said you
instruction.
could form premeditation while you're manually strangling someone.
Right, but it's the instruction is thought the matter over beforehand. So I'm interpreting that to mean form the design or intent to kill before the actual fatal act. So I think with strangulation, there's some idea that the fatal act takes time. That's how I'm interpreting those cases. But again, it's that idea there has to be some reflection. The only way you're going to distinguish premeditation is that there's some design or intent to kill before the act. The design is formed before the act, which again, that case I cited in my brief talks about reflection, implies reflection.
So it's basically your position that a mental disease or defect can negate premeditation, but it might not negate intent.
No, I don't think that's what I'm saying. I don't think you even need to give the instruction. I mean, if you didn't even have the statute, all the statute did was do
Well,
away
why
with
not? I
insanity.
mean, is there an instance in which mental disease or defect can negate premeditation and not intent? That's what you're arguing. There is an instance.
No, I'm not trying to argue that.
That's what happens when you prevail with your defense. It doesn't eliminate the criminal activity, it just lessens the degree. So
Right.
that is what you're saying, isn't it?
Well,
Or am I totally
I thought that's what you were
it's just
saying.
it's just an element of the crime. But we argued this before the last time that I was here. I don't think you need the instruction at all. We don't instruct juries that we've presented evidence to consider that evidence to an element of crime. It's common sense. You present the evidence, you give the elements instruction, the jury applies the evidence to the elements. You don't even need this instruction. I mean, we're talking about evidence of mental illness here. That's all. It's relevant evidence. It's relevant to an element of the crime. That's it.
That goes back to my question. How is it relevant to the timing? And I know you already answered that, but I guess I'll pick up on what Justice Rosen said. In this case, we know that the jury found that the intent was formed, and they considered the evidence of mental disease and defect. So you are asking us to say this is a case where a jury could actually find that the mental disease or defect did not defeat the element of intent, but did defeat the element of premeditation. And I don't understand how that logically is possible.
And I don't think I'm understanding your question.
Well, in this case, we have a jury that said the defendant formed the intent.
Her mental illness did not preclude her from forming the intent.
Right.
Right.
But somehow it would preclude the timing of the formation of the intent. That's, I guess if the defendant could form the intent, then she could form the intent at 9:05 or 9:10 p.m. or 9:15 p.m. or 9:20 p.m. I mean,
And that's I mean, if that's the way this court wants to define premeditation, then that's
isn't that,
relevant.
but I guess that's my question. Isn't that how we did define it in McLean?
Right, and again, I'm just going to say the same thing I've already said, which is her thought process about why she acted the way she did
Okay.
is relevant to that question. And I mean, this court has recognized that by saying that somebody who acts with voluntary manslaughter isn't premeditating a crime. And that's all their subjective state of mind, whether it's voluntary, whether it's heat of passion or imperfect self-defense. You're basing that on a defendant's subjective state of mind.
But I understood your argument to be that her mental disease or defect caused her to carry the instrumentalities of death into the room because she perceived a threat that was different than what she encountered, and then the intent to kill was formed instantaneously when she thought there was a need to defend herself. Is that your argument?
That's what she told her expert. She told the detective that they asked her, when did you form this intent? She said in an instant, in the moment.
So that would be like I heard a noise in the garage. I took my weapon, went out there, and someone rushed me and I shot.
No,
kind of
the rock and the knife were the defensive weapons because that's where she thought these people were trying to get in, were in her son's room. That was all part of her delusion that these evil forces were coming in.
Your argument in answer to my colleague's question is that the mental disease or defect caused her to have these instruments, deadly weapons with her.
That's right.
But it didn't necessarily prove that she had thought the matter over beforehand of killing this particular person.
Yes,
Is
absolutely.
that what you're saying?
Yes.
Is why it was, okay.
She
Yes.
went into the room basically on defense with the weapons, and then,
Right.
then it turned to offense.
And then she patrolled the house, and she kept patrolling the house. And then at some point, that was it. They were in the house. They were coming for them. And that's when she said she picked up the weapons and used them.
Any further questions? All right, thank you, counsel.
May it please the court, I'm Kerwin Spencer, Summit County Attorney, here on behalf of the state of Kansas, the appellee in this case, and as accompanied today by Mitch Spencer, Assistant County Attorney. As the defendant was patrolling her house, she, amongst other things, got all of her medication that she had and poured it in a pail and put it on the stove and was mixing it up, as she told her counsel, the experts, intending to put together a concoction to feed her children to kill them and put them out of, save them from further misery later. She rejected that. She thought about it, got away from that. That was no longer her plan. So then she goes on patrol, carries around a knife, and then decides that she's going to take her son's life to send him to heaven tonight to save him from further suffering. This knife isn't the best thing to do it with. I'm going to go to the bathroom and get the rock and take it in and then have it there. And that's, in essence, what she told Detective Wilson. And then it was some 3 or 4 months later when she talks to the specialist then that she tells a slightly different story about forming an intent within an instant. So she had plenty of time to get together and figure out, well, what's a possible defense? So I focused, and I argued to the jury to focus on what she told Detective Wilson that after she talked to him multiple times. And the defendant in this case got every instruction that she asked for and did not have any instructions, any objection to instructions that was in fact not sustained. There was only in fact one objection, and it dealt with the supplemental question of if you find the defendant not guilty because of reason of mental illness, not only to first-degree murder, but second-degree murder is the reason for that. And it was 2 questions there. The judge decided, well, that's really not what we want to do, so he gave only the one question of if you find the defendant not guilty because of was it because of mental illness? So, in fact, there was no objection that went against the defendant as it relates to the instructions. She got all the instructions that she asked for. She got to introduce all the evidence that she wanted to introduce. And the jury still decided beyond a reasonable doubt that she was guilty of premeditated murder. So, of course, the significance of the instructions being what the defendant was asking for is for there to be a reversible error. It has to be a clearly erroneous standard. That is, you have to come to a conclusion that something that the trial court said was wrong, and then did that error cause, are you firmly convinced that but for that error, the jury would have rendered a different verdict? So this is not the case to argue that, well, the defendant should have been able to introduce more evidence, or because she got in all the evidence that she wanted to. So in essence, she got all the instructions that she wanted, and then you have to determine that, well, if we'd have given this instruction, if the trial court would have given this instruction differently than they did, then the jury would have come to a different verdict. And the defendant retains that burden. It doesn't shift to the state. The defendant has that burden to show you.
Well, on
Mr.
that.
Spencer?
Go ahead.
Yes.
Okay. If premeditation is not part of a culpable mental state or a part of it, what is it?
It is a separate offense. And an
Element of an offense.
element of the offense. Under
Right.
215202 sub G provides that the definition of a crime, if the definition of a crime prescribes a culpable mental state with regard to a particular element of that crime, that culpable mental state shall be required only as to that specific element. It shall not be required as to any other element of the crime.
I don't understand what that has to do with telling me that premeditation is an element. But you agree with me, it is an element of the crime.
Premeditation is an element of the crime,
And so
it's
if
not subject to a culpable mental state analysis.
I understand that that's your position, and I understand what we said in McLean. I also understand what I said in McLean. But at any rate, if it's an element of the crime, then why shouldn't the jury be able to consider evidence of mental disease in deciding whether the state has carried its burden to prove premeditation?
Well, if you look at the specific instructions that were given by the judge. That included telling the jury that you could, that you consider instruction number 6.
I've got it. It said the defendant is not criminally responsible for her acts if because of mental disease or defect the defendant lacked the premeditation and the intention. It did set it out as a separate element. I think the difficulty arose later when the jury asked for a definition of culpable.
Yes.
Is that correct? And then that time they were directed only to instruction number 2 and 5, right? And that's why the defendant's arguing that they were misdirected or misled about whether they could consider.
Well, actually,
excuse me, I'm not finished yet. Whether the jury would have understood they could still think about premeditation on mental disease or defect, right?
they were not just instructed only to 2 and 5. They were also instructed that the culpable mental state for murder is intentional, and the culpable mental state for aggravated assault is knowingly.
Right. That's what they were. Those were 2 of the other instructions, number 2 and 5.
Yes, exactly. So if you look at the language that the court used, it all, as reinforced by the McClin holding, was a correct statement of the law. So if you're to find that under the clearly erroneous standard, you have to find that was not a correct statement of the law. But in
That's
fact,
the first
it
thing
was.
we'd have to find. But your bottom line is, we already did what they're asking for, which was instruction number 6. The jury was told that it could consider mental disease or defect as to premeditation as a separate element. That's really your bottom line first argument, isn't it?
Yes, because
Okay.
that's what was done here, and this is not the case to argue, well, something different could have happened.
Okay, thank you. Did you want to ask a question?
Yeah. Draw your before the exchange you just had with Justice Beyer, I think you were talking about the actual evidence of premeditation that the state presented, and that's what I wanted to ask you about. Is it your position or your view that a defendant is precluded by law from advancing a mental disease or defect argument or evidence that provides an alternative explanation, if you will, for certain facts that the state's relying on to prove premeditation? Because that's how I understand the defendant's argument. They're saying, look, the state came forward with this evidence that they argue supports a finding of premeditation, but there's this alternative explanation which relies on evidence of a mental disease or defect, and the jury ought to be able to consider that alternative because that's how we, the defense, can rebut the state's evidence.
Well, there's State v. Pennington out there that says it really makes no difference whether or not it's based on delusions or not. The state has the burden of showing that the defendant acted intentionally.
We're not talking about intentionally now. We're talking about this. I'm specifically talking about the evidence the state relied on to show premeditation.
And it's, if I may,
Go ahead.
it's evidence the state relies upon to lead the jury to the inference of premeditation.
Right. That this intent was formed beforehand.
Well, the premeditation merely means that there's an opportunity to reflect. And that opportunity to reflect is by the fact that she was going from room to room.
Right. I understand you have evidence that you believe supports the charge. Of course you do. And you present that evidence to the jury and argue to the jury that they should find the element being premeditation based on this evidence. But the defense, the point is the defense has an opportunity to challenge your evidence. And if the challenge that the defense wants to make is, hey, there's another explanation, jury, you ought to really consider my client's mental disease or defect because that provides a pretty compelling, reasonable explanation for this behavior. Why shouldn't they be allowed to present that evidence?
They were allowed to present all of the evidence that they wanted to present.
So that's your argument, really, in this case. You're not picking a beef with the point of law. You're really just saying, look, Instruction 6 told the jury they could consider this, and the evidence came in, and that's what happened here.
yes, this is not the case to argue that there was more evidence out there that the defense tried to get in that wasn't allowed to get in. You know, the jury got to hear everything the defendant wanted to present.
In other words, because of mental disease or defect, the defendant lacked premeditation. That evidence was submitted by the defendant and
Well-
allowed by the court?
What I'm saying, well, the expert for the defense admitted that the defendant intended to kill her son and thereby send him to heaven. So that came in along with other evidence. What I'm saying is there wasn't other evidence that the defendant was trying to present that the court kept out, is the point I'm trying to say. And then you look at the instructions and see if they are, in fact, a correct statement of the law. And under McLean, they were a correct statement of the law, except for perhaps mentioning even premeditation, which I was arguing all along in my proposed instructions that we should just deal with intentional and not premeditation as it relates to the mental illness aspect. The court overruled me on that and gave the instruction as Justice Beer has said, but you know, that doesn't make premeditation a culpable mental state.
I understand. My question was, it's your position that when the jury instruction number 6 says, if because of mental disease or defect, the defendant lacked the premeditation to kill Caleb Lancet, you're saying the defendant put on such evidence. Is that right? Through the expert or some other witness?
Well, I argued all along that her entire intent was to kill and that she thought about it beforehand. So if she thinks about it beforehand, reflects about it beforehand, and we demonstrate beyond a reasonable doubt that she did premeditate, it's ipso facto, that means that she can premeditate, if in fact she did premeditate. And
I think we're all talking past each other. You're saying delusional intent's okay, that works to convict, and therefore delusional premeditation works also. I think my colleagues are asking whether if she's thinking about something other than the act of killing her son beforehand when she's doing all of this, even if she's thinking about killing, you know, other children or whatever, that the particular act that she committed, whether she premeditated that particular act or whether it was instantaneous. I think the mental disease or defect evidence would go to whether there was the actual premeditation, not whether it was delusional. So I think we're kind of talking past each other. Okay. And so why couldn't it have, she may have premeditated a lot of things, but did she premeditate the actual murderous act she committed?
well, the fact that she took 2 weapons in there indicates.
Well, but
We're
Counselor,
asking, I'm sorry, we're trying to ask what defense put on to try to contradict that. And my understanding is they were given that opportunity. So my question is, was there anything in the record besides your evidence of premeditation? In other words, did the defense have the opportunity and took advantage of it to show it was not premeditation for whatever reason?
Even though she didn't testify, her statement to her psychologist came into evidence. And in her statement to her psychologist, she amongst other things, says it all happened in an instant. But you could contrast that with what she told Detective Wilson.
I understand that. We were just searching to see if that opportunity was present and if she availed herself of it. And it sounds like, at least with that piece of evidence, she did.
Yes.
Okay. All right. Thank you.
Yes.
we've taken a lot of your time with questions. You're out of time, but I'll give you a minute to wrap up if you feel you need to.
I just want to underline that you look at this, so there has to be a clear error analysis, and the clear error analysis, the judge did not make a misstatement of what he actually read in terms of the McLean case as supported by McLean. Thank you.
All right. Thank you, counsel.
I just think the prosecutor mischaracterizes her as a little more opportunistic than I think the record supports. Is she's the one who made the 911 call. So the jury had that, what she told them on the 911 call. She said she had been in a hypnotized state. She felt she had been, I'm not sure she said this in the 911 call, so I don't want to misstate that, but it's a 911 call. You got the responding officer that shows up and sees her.
Ms. Davis, you acknowledged, however, that all of this came in. All of this evidence came in, right,
Yeah.
at trial? She wasn't prevented from putting on any
Right,
evidence.
and
That's
then-
not this case.
I disagree also that it's a misstatement of law, because the judge told the jury that the evidence of mental illness is to be considered only in determining whether the defendant had the culpable mental state required to commit the crime.
Is that
And
part
that-
of Instruction 6 as well?
That,
Instruction 6 tells the jury flat out that they may consider.
only
The evidence is to be considered only in determining whether the defendant
had the culpable mental
had the
state.
culpable mental state required to commit the crime.
Right.
But then later it says the defendant is not criminally responsible for acts if because of mental disease or defect the defendant lacked the premeditation and the intention. So that's there.
Right.
And there's nothing about the response. This is, I think, your biggest problem in this case. That is in instruction number 6. Instruction number 6 may be characterized as somewhat confusing, but it did not prevent the jury from considering mental disease or defect as part of the premeditation element on whether it would draw the inference the state was urging upon it. It didn't do that. It says right there they can consider it for premeditation and intention. And you want us to look at the only, and I've got that, but it also says that. So what is it about what was said in response to the question, the later question from the jury, that undercut that? Because unless you've got undercutting of that, I don't get the error.
Then the jury asked.
Even under my view of how premeditation fits into this whole scheme post 2011.
Okay, then the jury asked the judge a question, a written question.
Right.
It says, what is the culpable mental state?
I thought they asked for a definition of culpability.
No, they said, what is the culpable mental state that you're talking about in instruction number 6?
Okay.
The jury directly asked the judge, what is the culpable mental state that you're talking about in that instruction number 6?
Okay.
And the judge comes back and says, that culpable mental state is intentional,
Right. Which, according to McLean, is a correct statement of the law.
but it's not a correct statement of the law according to Yorick and Bethel. Because according to this court's decision in Yorick and Bethel, a jury can consider a defendant's state of mind or mental state in determining premeditation.
New York and Bethel predated the 2011 amendments.
Right. But that means what you're saying then is that you're saying with McLean you're trying to overrule those cases, and McLean didn't say that.
I'm not saying that, as you
Okay,
well know.
but McLean
But
didn't.
some people are saying that.
But McLean didn't
in
address
essence.
this issue because it wasn't litigated in McLean, because the state in McLean conceded that premeditation was a mental state element that the state needed to prove, so this was never litigated. But the judge did tell the jury asked, what is the culpable mental state you're referring to in the instruction? And the judge said it's intentional. That's the culpable mental state. First degree murder. And that's what jury considers evidence only for. And that is a misstatement of the law according to Yorick and Bethel. Because according to those cases, a jury can consider evidence of mental illness in regard to premeditation. There's no indication that with the recodification and this adoption of this term, culpable mental state, that the legislature intended to overrule those cases or intended to substantively change the mental disease or defect statute. There's just no indication that with that recodification, if you look at the report, there's a substantive section. Part 2 is a substantive section. There's nothing in there that says we want the legislature to change this statute. There's absolutely no indication. So there was no intent to do any of that.
Do you have any further questions? All right, thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under